Hi, good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. And today we are going to finish up the month of May. Can't believe 2021 is flying by so quickly here. I want to talk about alternative dispute resolution and specifically online dispute resolution, as well as knowing about bias in terms of adjudicators and where that comes up. Really great article and an accompanying playlist, which kind of drew my attention there. Anytime you reference Drake there, I think it piques everyone's eyes and ears there with the artist of the decade. So thank you so much, Marc, for joining us here today. And perhaps maybe you can tell us a little bit about your background here, and then we can get into those topics, as well as talking more about the future of paralegal practice as well.
Sure. Thank you very much for having me, JP. I'm a real fan of what you're doing here with Justice and Pieces, and it's a real treat for me to get to be one piece of that puzzle that you're putting together with all of these episodes. So thank you. I appreciate the invitation. I'm historically a mediator. I've been practicing mediation for about 20 years. And in the past 5 or so years, have gotten involved in some tribunal work and into mediation and adjudication as well. So that's a little bit about what my background is. I've kind of felt like mediation always came a little bit naturally to me, ability to empathize with different parties and to try to collaborate and work together to find a way forward. But I also have always had a little bit of a love for technology that I inherited from my father. So have very much enjoyed being able to combine the two in practice and have been doing it for some time now.
Let's start, with COVID, and certainly over to June now. It's been almost a year and a half kind of lockdowns and unlockdowns and relockdowns. But as I was just telling you before, you were doing online dispute resolution before it was cool, right? Before everyone was doing it, right? It's kind of like the trend before everyone jumped on board. So maybe you could start by comparing. I think you even wrote about this, about online dispute resolution, the old online dispute resolution versus what it is today, and kind of maybe kind of just give an overview of the differences, and then we can certainly talk about how students can be better advocates in this forum.
For sure. So what I found was before the pandemic, online dispute resolution in private practice especially was not really considered the standard. It was considered a bit of a novelty. So I would get online work, but it was usually kind of unique circumstances. There was trouble scheduling with parties. I had a number involving paralegals where we had one party that was in another province, and it didn't make sense for them to fly all the way into Toronto to conduct an in-person mediation. Did have some people who were very much into technology and liked the idea of being able to participate online for a lot of the conveniences that we see today. The big difference, though, is it was an option, right? And with the pandemic, it no longer became an option. And actually what I found, and what I've said to a number of people who get nervous about the idea of participating online, is before the pandemic, it was a lot harder. There was more of an expectation of the technology working seamlessly. There was a bit of an expectation of perfection, because people were choosing it, as opposed to what's happened in the past year and a bit, where you've had no choice. If you want to go ahead with the mediation or an arbitration in this day and age, for a lot of the time during the pandemic, you've had to do it online. One of the advantages of that is not everybody is choosing it. So because you're not choosing it and you're forced to it, there's a little bit more acceptance of having some issues as you participate in the process, which I actually find humanizes it a little bit. We all have our gaffes of forgetting to unmute or having a bit of a glitch on our video screen and that kind of thing. And I actually have found that humanizes the process a little bit more and gets over some of the hesitations that come with participating online as opposed to in person, these feelings that it wouldn't be as personal. And just generally with so much of what we're doing these days taking place online, staying in touch with family and friends and taking courses and that sort of thing, I think it's just become a little bit more normalized in terms of people expecting to participate online. And there are some other aspects that also relate to the public justice system we can talk about a little bit later as well. That's kind of the overview and the key differences I've seen.
And what in respect to, I guess, an in-person, as we were just talking about there, in-person, let's go with mediation first. How, you're talking about humanizing, but is there a way to fully get that in-person, when you're sitting around a round table or, a boardroom table, however, as opposed to being here on Zoom or Teams or Google Classrooms or whatever they're using? Do you still kind of capture it in the same way, or from your experience, have you found it to be kind of identical as much as possible, or what would you say is sort of different with that?
The key criticism I've had generally of a lot of my fellow practitioners who had to stumble into online as a result of the pandemic is they tried to focus on replicating in person. But the key is online is not the same as in person. It's never going to be. It's disruptive, it's different. You need to use different techniques. So if you have some tried and true practices and tools and strategies you use in an in-person mediation, it's not necessarily going to work the same way online, particularly if you have parties that have different levels of comfort with the technology that you're using, who may or may not know each other very well. There are different ways that you can go about doing things. So for example, one of the classic knocks on online dispute resolution is there's no nonverbal cues, that if you're sitting next to each other, you can read somebody's body language. But that's not the case. Nonverbal cues just present in a different way if we're dealing with online. Think about emojis and text-based communications, for example. That can express a lot of how somebody's feeling. It can help make sure that if you're trying to make a joke, that you make it clear to the person receiving it that you are joking by putting a smiley face at the end and that sort of thing. I've actually found in my online mediation practice that I've been able to get people to bond and come together in sometimes even unpredictable ways. I had one memorable mediation toward the end of last year where we had two parties participating that had a lot of animosity. And one of them had trouble setting up their camera at the start of the mediation. And all of a sudden, the party they're in dispute with is giving them some pointers. And all of a sudden, they have something in common just to try and get themselves set up and make a laugh about using Zoom. So there are ways to find things that people have in common and work together and work a way forward. And always, I find with mediation, what you're trying to do is find some common ground. And you can do that online just as you can in person, but it's not always going to present the same way.
Right. So you're saying essentially, if you're trying to replicate the real world, sort of a real life in-person experience, you're not going to be able to like port it over to Zoom, let's say. But what would you do then on Zoom that you wouldn't do in person? And how, you're sort of, it's like a different animal, right? So what would you be doing to kind of, I mean, and obviously every mediation is differently, but things like maybe are you using breakout rooms a lot? How does it work?
Breakout rooms, not just with all of the parties or separating them, but being able to, for example, bring their legal representatives quickly together in a separate room to have a chat and then to go back. So that mixing and matching is a lot easier to do when you don't have the time of the steps that go back and forth and moving physically from one room to another. Being able to, while I'm in a caucus with one group, use my phone and text another group to encourage them to take a break or give them some idea of my timing. I find that helps a lot. And you're able to I joke, you can be in two places at once when you're conducting an online mediation. I found generally, though, that if you think a little bit further about just the atmosphere that parties are participating in, a lot of the mediations I would do in person were in environments that were unfamiliar to the people who were involved in the dispute. If you're, say, mediating in a law office, it can be a very intimidating environment for somebody who's not used to that. It's a big difference if they're able to participate from the comfort of their own home with their pet nearby, with their favorite snacks handy. So I find that some of the flexibility that's offered through online processes give us some options to make the situation a lot more comfortable for those participating in it.
Yeah, you mentioned the food. I mean, I guess you're missing out on the in-person lunch spreads there that would be at places like Network and sort of. But I mean, that also probably helps getting people back into the room, right? That they're not kind of wandering around the building there waiting for the other side to kind of finish up, right? But in terms of then being in the comfort of your own home, I mean, do you tend to run into any, I mean, technical issues can come up at any point, right? But do you find that sort of people are not familiar with a Zoom or the technology or just being able to, I mean, mute, unmute, et cetera?
I think that at this point, there's generally an understanding. One thing I do is I offer all of the parties that I'm working with a chance before the mediation to do a test run. And it's usually with each party separately as opposed to everybody all together. And it's really premised on giving them a chance to test their technology, just get an understanding of how I'll use Zoom for mediation. So, throw them in a breakout room so they know what that looks like, because on their weekly family check-in calls, they don't use that Zoom feature. And I find that what that does is not only give them a layer of comfort to know what to expect, which I think psychologically goes a long way to allow them to be comfortable participating in the mediation. But it also gives me a chance to build some rapport with them ahead of actually participating in the mediation process. And that's harder to do in person to be able to schedule. I used to try to do it with conference calls, but even that is not the same thing as being able to, through a platform like Zoom, look at somebody and talk to them. I also like to make sure that I have more than one way of communicating with them. So if somebody's internet freezes up on them, having an email address or a phone number to be able to keep the communications going. And I find that that also helps make them a little bit more comfortable with the process. They get to know me, they know what my role is in a mediation, and that can really help overcome some of those hesitations. One difference, though, I will say, is early on in the pandemic, whenever I would offer legal representatives the chance to participate in one of those, they were much more likely to take me up on it than they are now. I find that as we have paralegals and lawyers who are fairly new to participating in online mediation, if they hadn't done that before, they like the idea of putting in the time to participate in some kind of pre-meeting with me to go over some of the features. And these days, I find that's less and less the case, maybe because they've had one or two under their belt, so they feel like they know the ropes. But I've always said that the most difficult people to work with in mediation are the people that have participated in one mediation before. Because I find that people who participate in one mediation before kind of expect all mediations to play out the same way, and mediation is always different.
Now, the other thing, I sometimes get this in class, is you don't have the same ability of controlling the room as easily as if it was in person, right? In terms of saying, okay, well, that's it, we're going to hear from the other side. I don't know how contentious some mediations may get, but in your experience there over the last year plus, have you found that to be a challenge as a mediator?
Well, I think the biggest thing is the power of the mute button. You think about it, in an in-person process, you wouldn't have the ability to prevent somebody from being able to speak, take away their voice. And I could see a party being very offended and think that the mediator is potentially being biased or not letting them say what they have to say if that mute button is used on them during a heated section of a mediation. I've had to threaten to use it a few times. I've actually found that what's really helped in terms of helping people feel heard and getting them to be quiet is the share screen feature. So what I always do, if I have materials ahead of a mediation, usually when you go through them to prepare, you can get a sense of what are going to be key items for each party. So sometimes as they're talking, or if they start to get heated, I'll, without warning anybody, all of a sudden share my screen and pop up a letter they're talking about or a photo they're talking about. And I found that's incredibly powerful to help them feel heard, because it's a way to demonstrate that I understand what they're talking about that I can't possibly do in person. And it's also a way to get everybody's attention. So that usually helps me regain control. But certainly, you don't have the same types of control that you have. It's not as though you can lock the door in like a mediation room and people can't leave unless they pass you. You have to find different ways to try to encourage them to participate. But the technology is there to allow for that. I really do believe.
Now, it's great that you're here today, because last Wednesday, my students were doing mock mediations, and it was certainly a challenge. I think, especially I had assigned each group there have a mediator from one of their classmates. So even doubling up there on either you're a paralegal or the client themselves, or you were a mediator. And I think they found it very challenging, especially we had like a 30-minute time limit. So it really makes it difficult to get the parties to get some consensus. So perhaps maybe you can start by sharing some maybe advice for if you were a practitioner and you're now involved. And I think, a lot of the people I've been talking to in mediation, I referenced back in law school, you have all these great trial advocacy courses, but I'm sure now in like the last 15 years, there's more of an emphasis on ADR, but it wasn't given that same way, which is kind of funny because like 90% of your matter is resolved, but there's this emphasis on trial and mooting and mock trials, which is amazing. But what about the other aspects? So maybe you can talk about some practical tips. And I know you had spoken a couple of weeks ago at the ADR for paralegals as well. So maybe you can share some of the stuff there about how to be better in the alternative dispute resolution, and specifically online as a representative.
I think the key is to do some preparation with your client. Too many lawyers and paralegals that I've worked with over the years show up on mediation day and aren't on the same page as their client. Increasingly these days, people want to be a little bit more hands-on in participation in their processes. But it can be a challenge for you as a legal representative if you have a client that's going to say things that you don't want them to say. So being able to do a little bit of a check-in ahead of time to figure out when it might be appropriate for them to speak in the mediation, what are the key important things for them to talk about, what are the risks of areas where they might get distracted or emotional, so you can help them keep that in control and keep focused on what you're there to do in the mediation. So I really do think that preparation is the number one, to get a sense of what it is they want to achieve out of mediation, get a sense of what might be realistic outcomes. One of the things, as I'm sure you know, JP, like with mediation, the whole idea, it's not necessarily a pass-fail type situation, whether or not a mediation settles. Not every mediation is meant to end in settlement. Really, what you're there to do is try to generate some options. And the parties should really select what option is best for them. Sometimes that's settlement, a lot of the time that's settlement, but sometimes it's not. Sometimes it's proceeding to a more adversarial process. So I think that doing a little bit of homework and reality checking with your client, so they have a sense of, okay, what's going to happen if we don't settle this mediation? What are our next steps? How much time is that going to take? How much is it going to cost? Allows your client to have a sense when they have the settlement options on the table in a mediation to really select the way forward that makes the most sense for them.
Right, because sometimes, you don't necessarily know when the client is going to speak or when they may be asked to speak. I mean, is there a situation where you, rather than hearing from the representatives, you go right to the client, or is that kind of something that if they want to volunteer to sort of bring that up? I mean, I know obviously every mediation is different in terms of like maybe even like the opening statements that may be given. Do you sort of tend to see more involvement of late and on Zoom, or is it kind of still been all over the place like it has been before?
I've seen that can be a little bit harder for lawyers and paralegals to stop their client from speaking if they want their client to stop speaking, if they themselves don't have the power of the mute feature, right? They're not necessarily in the same room in this day and age, so somebody starts talking can be a little bit difficult for the legal representative to control their client. Generally, I do think it varies by the dynamics of the situation. As a normal practice, for me, the legal representatives make opening statements, and then I open the floor if either of the parties want to say anything themselves. Sometimes it's important for them too. But I usually like to try to really work with the legal representatives to see what they are comfortable with and what they think is best. They usually have a much better idea of where their client is than I do. So, there are situations where it can be helpful for a party involved to speak and get something off their chest and share their perspective. But there can also be times, particularly if they're emotional, when they can kind of shoot themselves in the foot if they say too much. So I kind of try to work with the legal representative to see what's most appropriate. But I really do care a lot about the procedural experience of the parties. And I do find mediation is an opportunity to let them feel heard that just isn't available in other types of processes. So we do try to take full advantage of that.
And in terms of, you mentioned it's not always going to settle, but do you often see that there's like a follow-up mediation these days, or is it kind of one and then they're pushing to trial, and if they resolve it, they're going to do it on their own accord afterwards?
Often, and increasingly so these days, I find that if a mediation is not going to end with the resolution of a matter, we usually try to keep a window open for some sleep on things a little bit, maybe exchange a final settlement offer, at least keep the communication going. In the work that I've done, there's a lot of uncertainty about if they're going to go to trial, when a trial date's actually going to happen. The courts were already backlogged before the pandemic. That certainly hasn't gotten any better. So sometimes over the course of just thinking about what happened in the mediation and getting a better sense of how long it's going to take to get in front of a judge, they do decide to reconvene a mediation or to reconvene a negotiation without the mediator present, to at least try to narrow issues or figure out a way forward. A lot of the work I do tends to involve people that have ongoing relationships. And as you can imagine, if you have an ongoing relationship, if it's going to take you a year to get an outcome, it usually does help to, at the very least, get some kind of interaction plan going or try to get an understanding around how communications are going to go, to avoid the situation where you have one legal representative playing games and dropping some big correspondence at 5 o'clock on a Friday before a long weekend, just to make it more comfortable and less stressful for everybody. And usually in those situations, you can make progress. Sometimes it's not always a full settlement or nothing. Sometimes it's little steps, but keeping the communication going, I find to be key.
I guess maybe to backtrack a bit, let's talk a little bit about the different matters that you find yourself dealing with in terms of maybe subject area or personalities. I mean, what are you sort of dealing with?
My original background, the law firm that I've been involved in for about 20 years, specializes in condominium law. So a lot of those, they run into a range of different types of disputes because condominiums are involved in all sorts of different things. They contract work, they have employees, there's infighting with the boards that govern them, there's disputes between neighbors, there's disputes between people who reside in the community and investors who don't. Sometimes they're not even in the country. So there's a range of different types of disputes that come up, and it touches upon a few different areas of law. Sometimes it can get very technical and engineering and heating systems and that sort of thing. Sometimes it gets very personal if you're dealing with pets and noise transmission and that sort of thing. It really kind of goes all over the place. I also find myself involved in corporate type disputes, contractual issues, infighting with corporate boards that have issues, terminations and that sort of thing as well.
Now, is it? I know there's like I don't think it's too long. Maybe I remember I had someone in from Condo Boy. There's like a board, it's like a tribunal type of avenue now. I don't know if it was too long that has been used, but is there like mediation sort of built into that process, or is this kind of all happening kind of at the whims of the parties?
So there's a couple different sections for my answer. I'll try to keep it quick. The first is the Condominium Act directs certain types of disputes to mediation and failing mediation arbitration. It requires certain disputes to go that path. And they do have backups of court decisions that have actually kicked parties out of court back to mediation and arbitration if their dispute falls into that zone. Since 2017, there's been what's called the Condo Authority Tribunal. I'm an original member of it, but I have to use the disclaimer that I'm not here to speak on behalf of it. It's like tweets don't equal endorsements type of thing. They've started off with a very limited jurisdiction. It started off with just records disputes. So typically an owner wants to get some kind of records that the condominium has. They're not able to deal it on their own. They can go to the tribunal, which has a three-stage process that first encourages the parties to negotiate themselves, then offers mediation. Failing mediation, they'll offer a tribunal decision and it'll go to adjudication. Now, that tribunal jurisdiction has recently expanded into some other disputes, but in the grand scheme of things, it's still relatively narrow. The thing that I found the most in the world of condominiums is most of the mediations that I've facilitate tend to fall more into the voluntary zone. They might have one or two areas that could, depending on interpretation by the Condominium Act, fall into mandatory mediation or arbitration. But usually most of the parties that are involved in condominium disputes, one party or another requests mediation and the other doesn't want to reject it. Part of the reason for that is we have a series of court decisions out there that have hit parties hard if they're seen to take a heavy-handed approach. So there's been parties that have spent a lot of money to go to court, were completely successful in their legal arguments, but weren't able to recover a penny because they were seen as being too aggressive. So generally in the world of condominiums, if a party suggests to you that they'd like to try to mediate, unless you're dealing with a situation where there's a safety concern, it's a good idea to go ahead and to try to mediate and make the most out of the opportunity to do so.
Perfect. Now, in terms of that, then the next stage goes on to arbitration, right? And I think there's even when I was teaching the course, that it's far more formal than mediation. But how would you prepare differently, or from the people obviously that come before you in all those years? I mean, in terms of preparing, I think the first thing, the word there, preparation, as you mentioned, is critical in both. But how do you look at it differently when you go to arbitration now versus with mediation, and certainly even with litigation in the courts?
Well, so mediation, really, you're trying to encourage the parties to work together. The focus is less on the mediator. It's more on getting the parties to see if they can find an agreement and focus on one another's interests. As soon as you switch to arbitration, you're trying to convince the decision maker that they should decide what you would like to see as the outcome of the dispute. Now, I do find that we're able to streamline things. There's a degree of flexibility in terms of the process with arbitration as opposed to going to court. Often I involve the parties in setting schedules, for example, to be able to work with them for submissions. Even before the pandemic, I found an increase towards going documents only for arbitration, which kind of naturally blends into online arbitration. So there is flexibility in the process, but ultimately at the end of the day, the arbitrator is going to make a decision for the parties. So their focus has to be not on being concerned about satisfying the interests of the other party anymore, but being able to have a strong legal argument in favor of the outcome that they would like to see.
And I guess that overwhelmingly they're going to be binding sort of arbitration decisions, or is there?
For the most part. So it's a lot harder to try to set aside or appeal an arbitration award as opposed to appealing a court decision. Part of that is in arbitration, most of the time you select the decision maker. So you've agreed to have this person decide the outcome of the dispute for you, where with the public justice system, it's kind of luck of the draw on who you get. And arbitration agreements and appointments usually do a lot to limit appeal rights, because the whole purpose of participating in a process like this voluntarily is to get closure. So you don't want to drag out a dispute for years by appealing the award. I should mention that the one other area that I do see arbitration come up quite a bit is in contracts. So in agreements, you hire somebody to do a job for you, and there's a dispute resolution clause in there that says, look, if there's going to be a problem, we're not going to go to courts. We're not going to make it public. We're going to settle this through a private dispute resolution process. If we can't do it through mediation, we do it through private arbitration.
And I guess the same thing that we were looking at before with mediation. How are you seeing online arbitration over the last little while versus before, or even, I mean, in person as well?
Well, one of the things that I find that's really neat is with Zoom, you can cut down some of the costs. So for example, traditionally in an arbitration, you would hire somebody to transcribe if a witness is giving testimony. You can do that with Zoom right now by recording the meeting if you were to do it that way. So there are some ways to streamline the process. There have been ways to be able to be a little bit more flexible in how it goes. Asynchronous process is the idea of breaking up the process into a series of events. Often find when working with paralegals or lawyers in a process like that, they can handle a lot of it themselves in terms of the scheduling, in terms of everything, to minimize the amount of time that they need me involved, which overall reduces the cost of the process for them.
And again, that's the other thing there in terms of access to justice, certainly, that it's so much cheaper to, I mean, you don't really need any money there outside of paying for the arbitrator or mediator themselves. I mean, compared to renting out a facility, getting 3-4 rooms at that place, and again, the whole day. Now, in terms of that, and looking at preparation again from the practitioner's point of view, anything there in terms of preparing for an arbitration, whether online or in person one day, in terms of that's like we were just looking at, that's a little bit different there. When you have that finality, I mean, is it essentially like preparing for trial at court at the end of the day, or is there something a little bit different than that?
I think it's a little. It can be a little bit different because it can be a little bit more flexible than going to court. You know, I find that less can be more. A lot of the times in arbitration, there's more of a tendency these days to limit submissions in a way that you wouldn't necessarily in a court of law. There's a way to be able to involve the party a little bit more directly in making submissions if you need. So there can be some flexibility there to make the process a little bit more comfortable for those participating in it. One of the things that they say, as kind of can lead to the part of the paper talk, is that people are more willing to accept an outcome if they feel that the process they had participated in was fair. And a lot of times the traditional court process can be really hard for somebody who's unfamiliar with it to navigate. Self-represented parties have a heck of a time with it, especially. But even if you have representation, it's an intimidating environment. It can take longer than you thought. The decision maker might give you a little bit of attitude, as some of them are known to do. I think with an arbitration process, you can make the process a little bit more comfortable for those participating, to really give them a chance to feel heard. And in turn, they're able to better accept the outcome, even if they lose in circumstances like that. And that's been found in an online dispute resolution context for decades. Like back in the 90s is when ODR first started. It didn't really take off for a few different reasons, but when you consider things like eBay and Amazon, they have had dispute resolution mechanisms since they launched in the mid-90s. And even some of the studies that took place as long ago as the late 90s have found that when parties feel as though they're able to be heard before a decision is made, it's easier for them to accept the outcome and move on. So I do find with arbitration, if we keep that in mind, we can do more to structure the process to allow people to be more accepting of the outcome, even if they don't end up with the resolution that they like.
All right, perfect. So let's, I mean, probably a couple more things that we can circle back there in terms of students who want to go in and be mediators and arbitrators. And we'll probably end with that in terms of advice and getting to that stage, as well as the future of the paralegal practice. But I know you just brought it up there, so I wanted to bring it up before I forget later on there. Now, you suggested essentially that in your paper that familiarity, I believe, with Drake is indicative of an adjudicator's capacity for empathy. Now, what does that mean? I mean, I think that's captivating right off the bat there, that it causes you to sort of pause and think about it. But maybe I'll leave it to you to explain that, and then we can follow up about the bias and the rest of your article.
So back in 2018, I was working towards a Master's of Law in Dispute Resolution at Osgoode. And one of the major papers that I did, my research was focused on decision maker bias. And in the course of my research, I came across this tale from the 1960s in the UK of a judge who is not familiar with the Beatles, who, of course, in the 60s in the UK were all the rage. And the argument in that paper was basically that the judge was so out of touch by not being familiar with who the Beatles were that they weren't able to empathize with the parties, that they had no idea who was coming before them. They had no idea about society. And that got in the way of them doing their job, of them delivering justice. Back to that whole procedural idea, the theory is that everybody who comes before a judge, whether it be the parties, their legal representatives, witnesses, the person sitting in the public trying to watch it take place, the decision maker needs to be able to relate to them in order to properly do their job. As you know, around the time I did this research, Drake had more slaps than the Beatles. It came out, right? So naturally, that's where my thought process went. Well, in the 60s, a judge isn't in touch because they don't know who the Beatles are, then certainly in this day and age, the last decade, as we know, you'd have to know who Drake is. And if you don't even listen to music, at the very least from the Raptors run in 2019, you should know who Drake is. And I just think it's kind of funny because there's been so much these days that talk about the importance of having a diverse judiciary. I just really like what the idea of this concept represents in this day and age when you look at it in comparison to the stereotype of the old white judge who wouldn't necessarily know many of Drake's songs. So kind of in jest on Spotify, I put together a playlist, all clean lyrics of introduction to Drake for adjudicators, where an adjudicator who is unfamiliar with the music of Drizzy to be able to listen to try to be a little bit more in touch with what's going on in this day and age.
I think I must be very empathetic if I can sort of rifle off, from the first few albums there until before, to today. I know I just got the Artist of the Decade there with the Billboard. So interesting. I mean, I think that's a great comparison. I mean, Drake himself makes that line there, right? I can't remember what song it is off the top of my head there. I think with believe it was Meek Mill, but
yeah, going bad.
Yeah, exactly, right. So again, he's sort of the modern day equivalent. If you're not familiar, I mean, it does kind of raise that question there that what does your judge know, or what does the tribunal adjudicator know in terms of what's going on in terms of context? Now, I mean, you also posed up some other questions there. I mean, even the video with the cat filter there, as well as what if you're I'm connected with a few speakers who are judges and adjudicators. I mean, if someone follows me on Twitter, I mean, now is there a reasonable apprehension of bias because could we have communicated at some point? I mean, what does that mean? I mean, like, you wouldn't have that connection with a judge even 25 years ago. I mean, probably even more recent than that. So how do we look at all of that today?
Personally, I think that the age of greater transparency is a good thing. When we're finally at a point now where we're willing to acknowledge that there has historically been and still is systemic bias in place, this gives us an opportunity to do things to address that. One of the things that I say in the paper is just because a bias isn't expressed doesn't mean it doesn't exist. So I think that it's really important for us to be able to keep in mind, and the idea is that an adjudicator could have many reasons to be on social media beyond deciding the case that is before them, right? So when you look at the concept of bias, You differentiate between actual bias and perceived bias. The test is established by the Supreme Court is a reasonable apprehension of bias. What would an average person think in a circumstance? There was a case recently that came out from the Ontario Superior Court that recognized that a mediator or an arbitrator liking a tweet from a law firm isn't an indication that they're going to decide in that law firm's favor when that tweet has absolutely nothing to do with the case at hand. There has to be a reasonable line. We all have biases. I think we're finally getting to a point where we're no longer trying to say that just because a decision maker hasn't expressed a bias because they don't have that transparency means that they're not going to be biased, that it doesn't exist. We bring it up to the surface a little bit to allow there to be a degree of transparency, to accept that it's okay for an adjudicator to have lunch. It's okay for an adjudicator to post a tweet, but there's a line that they should not cross in terms of that test of reasonable apprehension bias. So in the States, there are some tribunals that have very detailed social media policies that won't allow their decision makers to participate on certain platforms. Facebook is a real tricky one just because of the perceptions of friends, of being connected to somebody in friendship. But the general idea is that adjudicators have to hold themselves to a different standard than the average person. They maybe shouldn't spout off on every political issue that comes up that may end up finding its way before them. If you don't like a decision that's been released and that decision may very well end up being put before you in a future case, it might not be a good idea to publicly criticize what you don't like about that particular decision. But that doesn't mean that you can't have any activity whatsoever on social media. And the former dean of Osgoode Hall Law School, Lawrence Dawson, who's a judge now, has remained active on Twitter, even though he's now on the bench. And I think that's a good example of how you can still participate, but you have to participate with a reasonable objective of not coming off as being biased. But if you do, and that's a problem that we can express, I think it's easier to identify a problem in this day and age than it was 30 years ago. Right. So I see it as a good thing overall for the justice system to increase that level of transparency.
Right. It's not that you're suddenly unbiased just because we couldn't find, your old tweets back in the 80s. Right. I mean, and as well, I mean, just because you become a judge today and those biases don't just disappear with you upon your appointment to the bench, right? So again, I think certainly if it does give that reasonable apprehension of bias, at least it's out there for it to be brought up in a motion or an application, or I mean, frankly, I mean, I would think that where that was alleged that and it was a serious enough allegation that they would recuse themselves before it even got far enough. I think I would respect the bench there to understand if they see that situation that they can walk away rather than let it be an issue.
Yeah. Now, one of the things that I found in my research was the whole idea is a judge isn't supposed to have an empty mind. They're supposed to have an open mind. So when they take on a case, there are times where subject matter expertise is really helpful. If you look in the private processes of arbitration, a lot of the times the parties like the idea of being able to select the decision maker, and they go out and they select a decision maker who knows something about the subject matter of the dispute, who has some experience in the past. There's always a chance that experience could influence them to be biased in a particular way on the outcome of the particular case at hand. What the test is and what the decision maker needs to do is show that they're open to persuasion, that they don't come to a case already having decided what its outcome is, that anybody who makes a submission before them, they will consider it and they have the opportunity to be able to convince the judge that should be the outcome of the case. And as long as you're open to persuasion, having that degree of subject matter expertise and experience can actually make you a better decision maker. But there is a balance, a delicate balance there in terms of perceptions and what's appropriate and what's not.
Right, because I think sometimes, again, and this might lead into sort of the last thing I wanted to talk about is for paralegals specifically in terms of their practice and opening up opportunities in ADR. I mean, I always mention to them, look, you don't need to have all this experience or this lengthy education. Certainly, they're going to be asked this because why you as opposed to anyone else then as to be the mediator. But what about then, you can certainly be a mediator, adjudicator without having that subject matter expertise. So, I mean, you kind of have pick your your pick of the crop there as to, do you want someone, if it's a very technical thing, you want that subject matter expertise, so you wouldn't want to shy away from it, given in the case of a judge, their 10 plus years of practice experience that's in perhaps that field, that they want to be able to draw upon it, and they can certainly take judicial notice if need be on certain things. But again, it comes down to the trade-off. Do you want someone with that, or do you want someone who just is there to help guide you towards the resolution in a mediation or in an arbitration? Do you just want someone who's going to look at it and make a decision based on their background?
And it's what we're seeing with administrative tribunals in the public justice system as well. The whole concept of having these tribunals is to have a little bit more specialized decision maker body than you'd get in, say, small claims court, where it's really luck of the draw. Like in my background in condo, there have been cases that go before the small claims court and the judge has no idea what the Condominium Act even is. By having a specialized tribunal and leveraging that subject matter expertise can deliver not only access to justice by delivering a faster result than you would get in the generalized system, but also a better result at the end of the day for the parties participating.
Right, and I think certainly then it raises those new issues that you wouldn't think about in the lens of 2020, 2021 that you were looking at in the 1960s, right? I mean, there's more out there. There's consumption. I mean, especially on Twitter. I mean, you have your character limits there, but you can be tweeting thousands of tweets. I mean, you see what happens if someone had said something in like 2015 or something, that there's a way to look that up and bring it back up.
But as opposed to a system where you would never be able to uncover that, doesn't mean the thought wasn't there, doesn't mean the bias wasn't there. So I think the greater transparency in the grand scheme of things helps ensure that we can address some of the traditional biases that are inherently in the systems that we have to deal with for seeking justice.
And certainly look at, again, making it more a diverse sort of, maybe that's something actually we can touch here in terms of, with mediation and with arbitration, certainly where you have your pick of well, to an extent, right? Obviously, the other side has to agree, but there's an opportunity there to have, I mean, we're talking about biases, but I mean, someone that may look like you and is being part of the decision. I mean, how are you going to, you're using Drake as an example, but I mean, if someone's not going to understand the situation, whether it's the Condominium Act, how are they going to put themselves in your shoes to help find out a resolution for you if they can't appreciate where you're coming from?
Yeah, and that's something that I see all the time in terms of the jockeying for position and coming to decide who the mediator is going to be or who the arbitrator is going to be. There are some lawyers, there are some paralegals who like to play games there and who kind of go out of their way to complicate it for the other side by only suggesting practitioners who are very expensive or who don't have availability for a long time. And I think that it really comes down to being reasonable. What I have seen is in situations where people are entering into a contract that has a dispute resolution clause, having something that sets out parameters to make it easier for them to decide on a decision maker. In this day and age, unfortunately, there are situations where if parties have to go to arbitration and can't agree on who the arbitrator is, they have to go to court to get an arbitrator assigned. And not only is that expensive, that takes a long time and is a waste of everybody's time. So being able to be more reasonable in selecting somebody who's capable, I think goes a long way in terms of being able to have a clearer path of how that goes and making sure that you're choosing a practitioner that's right. And most of the time, subject matter expertise in a lot of these disputes is a key consideration for parties who want to know that they're in capable hands of getting an outcome that's at least within the range of what they could perceive as being reasonable.
And is there ever like a direction towards, Adrio Click basically being able to just take, if they're unable to, let's say, pick a specific mediator, that they can be sort of appointed to assign one to you? I mean, I know obviously through the courts and tribunals, they have their own system where it is, but for the ones that are done voluntary, is that something that you can see people building into a clause, in the event that we're unable to reach a consensus, then we will give the power to so-and-so to take care of it?
Yeah, I've seen quite a few clauses like that, where if the parties can't agree, then each of them will select one person and one mediator or arbitrator, and they themselves will decide on an arbitrator, or you get into panels that can get more expensive. But I do think that those types of formulas can go a long way. I've even heard some people talk about like flipping a coin, which I don't think gives you the same perception of having a just process, but being able to have some mechanism in place to being able to address that privately goes a long way. And even if it means some kind of minimal criteria of who the person is going to be, designations or minimal education, insurance, experience, those types of things, to at least have a formula of what does our mediator have to be capable of? Do they need to know this particular area? Can go a long way to be able to avoid some of those unnecessary delays and complications.
Perfect. So I do want to now kind of finish off here with the paralegal practice as well. You know, my students who, again, they often they pipe up there. They hear, look, career opportunity in alternative dispute resolution as a mediator, arbitrator. I mean, some of them have that expertise. You know, they're coming from other careers, and then they come into the paralegal program, and I tell them, well, you still have all that expertise there. I mean, why not look at going and getting some further education and being a mediator? Given someone would probably look at that and say, well, you'd be great in this role. I mean, certainly you want to get some more experience and get some mediations under your belt, but that's an opportunity there. So maybe you could talk about what opportunities there exist for people into the alternative dispute resolution sphere, as well as what can they do to kind of make themselves better candidates for that role.
Yeah, when I first started my mediation practice, and it goes back some time now, I remember being in a program and talking with the fellow students who are graduating from it and saying, I'm going to focus a lot of my practice on condo, a lot of my marketing materials on condo. And they would say to me, why would you do that? It's such a narrow focus. And my thought process was that at least then, if somebody was going to compare me to another proposed mediator, I have something to stand on as to why they should select me as opposed to somebody else. That somebody who's overgeneral in their practice, they don't have any mastery of anything. And I believe as UJP in one of your earlier episodes said, you can't even master 5 areas of law. You need to find something that you need to get familiarity with and have experience in, because you can't practice everything to everybody. You won't be able to develop that knowledge and experience and expertise. So I thought that the first place to look is exactly what you just said. What's your existing knowledge base? What types of disputes do you see yourself getting involved in? One area in mediation that's considered to be very lucrative is family. But there are a lot of people out there who don't want to see the types of things that you see practicing family mediation, right? And if that's not what your calling is, why even open yourself up to that? You can get into a different discussion about some of the extra designations and whatnot that are needed to get into that particular area. But I think it's important to identify where you would have a competitive advantage against other mediators who are being proposed, and what types of disputes do you think you would be your best at getting involved in, and being able to really develop a practice there. Another aspect that I see a lot is a lot of people finish the education side of dispute resolution training and have trouble finding opportunities to get some experience. The way I did it was I volunteered out in the city of Mississauga at the Dixie Bloor Neighborhood Center a while ago, just to be able to take part in some community mediations on a volunteer basis. There are opportunities like that. As your students did last week, the idea of being able to do some role playing helps develop skills. But I think those types of things are important, because it's one thing to read articles and to study what it's like to mediate. It's another thing to experience being there in the moment. It's not something that you can fully plan out in advance. There are some skills that you need to develop of how you act in a particular situation as it arises. And you need to get that experience to balance things out. There are some groups out there. I think the community centers are probably the best way to get started. But there are a few groups out there that do look for opportunities to give people some volunteer exposure to getting some practical experience mediating. I think that's a really positive way to go. I know in small claims court, there's also something similar where they go around and try to help people mediate just before they go in to have their day in court. I don't think that's ideal, because as you can imagine, if you show up in court for your day in court and you've done all your prep and mediation hasn't even been proposed to you, might not have the best chance of success to switch hats and have you try to mediate in the moment. But I think for aspiring mediators, it's a way to get some experience. But with that in mind, I do think it's important to say that I don't think you should criticize yourself or worry too much about your success rate. Because in a situation where somebody's participating in mediation for free or unexpectedly, it's only natural for those types of mediations to result in successful resolution completely, less than they would if you had parties who had chosen mediation and had prepared for it, specifically trying to find a positive outcome for themselves.
Perfect. So thank you, Marc, for joining us here and sharing all that wonderful information. Perhaps if you have any final words of wisdom for the students, whether they want to go into a path of mediation or they want to just practice and be better prepared for online dispute resolution alternative, and we talked quite a bit about it, and or just in terms of overcoming all the challenges here, and certainly in terms of the pandemic and taking care of your mental health and diversity in the profession and everything like that. And thanks again for joining us.
Thank you very much for having me. I believe the quote's attributed to Albert Einstein, this whole concept of to do the same thing over and over again and expect a different result is the definition of insanity. But I really think that if the pandemic especially has taught us anything in a field that's been so slow to change, that if you do the same thing over and over again and always expect the same result, you're not going to get anywhere. I think that the whole idea of this field and what we've seen during this pandemic is the importance of being innovative and the importance of also being authentic and true to yourself. So while I talked a little bit earlier about the Raptors and you see my Kawhi picture in the background, Nav Bhatia, the super fan, was recently inducted into the Basketball Hall of Fame. And he posted a tweet that really touched me and I'd like to share with others, where he referenced how he promised his mother that he would never remove his turban. And now his turban is in the Basketball Hall of Fame. And his quote was, "Embrace what makes you different. It is your superpower." And I think that's the message I'd like to send that ties into what we were talking about in terms of leveraging the experiences that you have and the passions that you have. Don't feel as though you need to conform to what others or those who've come before you have done to find whatever they define as success. Chart your own path by following what you're passionate about and what you care about, and stay authentic to yourself. When I first started a mediation practice, the worst advice I got was, if you're going to be a neutral, you can't express an appreciation for anything. You have to be neutral about absolutely everything. You can't be, right? So choose your battles, yes, but don't sell yourself short. Stay true to who you are and be your authentic self. And I think that sets you up for success.
This is a couple of minutes left here before we wrap up. Pick one Drake song there off your playlist there, and can tell students there to end with taking a listen there, especially maybe something that they may not have heard.
Oh, Over My Dead Body from Take Care. I don't know how, it wasn't a huge hit, but it was one along with the two others that follow it in the playlist that I think say a little bit more about who Drake is, that I think is worth listening to. You know, I know nobody's perfect in this day and age, and there's always going to be haters, but I think that he's overcome a lot in what he's done. And I think that he's worked really hard to accomplish what he's done. And I think he has stayed as his authentic self. He didn't try to mimic the styles of those who were popular when he was first coming up. He charted his own path in a very unique way. So I think we can take that as inspiration. One thing I will say is I purposely didn't include Nice for What in the playlist, as much as I enjoy that song, because I do think there's a good reason for adjudicators to be nice. One of the things I mentioned in my paper was a story of a Saskatchewan judge who went viral earlier this year for judge slapping somebody and found out afterwards that he was mistaken and really was rude for no good reason, as far as I'm concerned, to the judge. I think it's important for us to be kind to one another and to be nice to one another. And if you see somebody struggling, whether that be somebody on the other side of a file that you're dealing with or just in your life, you don't know what they're going through. If you have the opportunity to exercise kindness, I think that you should.
Okay, perfect. So thanks again. And I guess I'll end with saying take care, everyone, and all the best.
Thank you so much for having me.
Thank you. Have a good night, everybody.